Hello friends, I am Satish Ahuja, editor of Legal Books. This time I am back with another important legal topic, and it is about the direction given by the Honorable Supreme Court of India to stop use of black money in the transactions. Friends, Section 269 ST of the Income Tax Act 1961 was introduced to reduce black money. It bans cash transaction above rupees 2 lakhs. If violated, penalty of equal amount is imposed under Section 271 DA of the Income Tax Act 1961. As per the said provisions, action is to be taken on the recipient. However, there is also an onus on the plaintiff to disclose their source for such huge cash. In this video, I am discussing a recent judgment delivered by the Honorable Supreme Court of India for controlling black money transactions. If any person files any suit in any court and in that he claims that he has given rupees 2 lakh rupees or more amount in cash, then what is the responsibility of the court which is hearing his case? Similarly, if any person mention in the document of sale purchase of property that he has given rupees 2 lakh rupees or more amount in cash, then what is the responsibility of the sub-registrar registering that property? Friends, under Article 141 of the Constitution of India, the law declared by the Supreme Court is binding on all courts across India. Also under Article 129 of the Constitution of India, Supreme Court is a court of record and has power to punish for contempt. Friends, if you find this information useful, please like, share and subscribe to my channel. This point was explained by the Supreme Court in the case of RBAN MS Educational Institution versus B. Gunashankar and another case, Civil Appeal number 5200 of 2025 and decided on 16 April 2025. In this case, respondent filed a case against the appellant to stop them from creating any third-party rights in a property. They claimed that there was an agreement to sell the property for rupees 9 crores and that they had already paid rupees 75 lakhs in advance in cash. The Honorable Supreme Court of India held that plaintiff filing suit must show source of such large cash payments. Further, following directions also given by the court to stop black money transactions. A. Whenever a suit is filed in any court with a claim that rupees 2 lakh and above is paid by cash towards any transaction, the court dealing with that case must intimate the same to a jurisdictional income tax department to verify the transaction and the violation of Section 269 ST of the Income Tax Act 1961 if any. B. Whenever any such information received either from the court or otherwise, the jurisdictional income tax authority shall take appropriate steps by following the due process of law. C. Whenever a sum of rupees 2 lakh and above is claimed to be paid by cash towards consideration for conveyance of any immovable property in a document presented for registration, The jurisdictional sub-registrar shall intimate the same to the jurisdictional income tax authority, who shall follow the due process in law before taking any action. D. Whenever it comes to the knowledge of any income tax authority that a sum of rupees 2 lakhs or above has been paid by way of consideration in any transaction relating to any immovable property from any other source or during the course of search or assessment proceedings, the failure of the registering authority shall be brought to the knowledge of the Chief Secretary of the State and or UT, Union Territory, for initiating appropriate disciplinary action against such officer who failed to intimate the transaction. Friends, if you want to understand this point more deeply, you can read the full Supreme Court judgment. Once again, the name of the case is Correspondence RBANMS Educational Institution versus B full stop Guna Shekhar GUNASHEKAR and another. Case number is Civil Appeal number 5200 of 2025 and the judgment was delivered on 16th April 2025. Thank you friends. I will try to bring you another video soon on another important legal topic. Till then, goodbye and take care. Thanks.